Very good evening to all the participants. Welcome to the 10th online lecture in the weekly series Know Your IP. During the last 9 lectures, we tried to focus on different areas of intellectual property rights. Today we have one of the most important components which help us in understanding the intellectual property rights better, and to speak on the core subject, the core area, theory of property and intellectual property rights. We have with us today Professor Y. Pratap Reddy, presently Professor of Law at ICFAI Law School, Hyderabad, IFHE. Prior to joining the IFHE Law School, Professor Pratap Reddy sir worked in different capacities in Osmania University, Faculty of Law. He was the chairperson Board of Studies. He was also the head Department of Law and spent about 24 years of teaching service in Osmania University. Prior to that, sir also taught in CRR Law College, Elur, and one of the best brains in the field of jurisprudence. I have had the privilege of being taught by him, of course, very unfortunately not in jurisprudence, but in legal remedies and other subjects when I was a student in University College of Law, Osmania University. And I had the good fortune of observing him for the last almost 28 years. And sir is an expert in jurisprudence, administrative law, law of evidence, law of torts, and law of consumer protection. And in fact, sir is the main resource person in the SWAYAM program, that is the MOOCs, right now currently offered through a consortium of educational communication New Delhi and English and Foreign Languages University Hyderabad. And he has presented 25 papers on different aspects of jurisprudence and different schools, different perspectives. And I'm very sure that most of you must have already joined this particular program. And Professor Pratap Reddy sir has been a research supervisor for many PhD scholars in their doctoral research, published number of research papers and articles in well-known and reputed journals of law, and also participated in number of national and international seminars, workshops, and conferences. Sir has a keen interest in the area of public interest litigation. In fact, PIL and socio-economic justice was the topic for his doctoral research. And he also has special interest in the areas of human rights, consumer protection, and juvenile justice. And sir has been a regular resource person on various subjects on law at the Judicial Academy, Dr. MCR Institute of Human Resource Development, and several human resource development centers, that is the academic staff colleges of different universities. Just one word, dear participants, in order to understand the true meaning of any legal concept or the contours of the emerging areas, one needs to have a sound understanding of jurisprudence. In order to understand the intellectual property rights, or intellectual property management, so on and so forth better, one needs to have a thorough understanding of the concept of property from a jurisprudential aspect. Therefore, we requested Professor Pratap Reddy sir to deliver a 1-hour lecture on this particular area, and also to explain the linkage between property and theories of property. And sir was kind enough to accept our request. Now I request Professor Pratap Reddy sir to make his presentation. Over to you, sir.
Good evening, everyone. At the outset, I thank the organizers of this program, especially the chair professor of IPR, Professor G.B. Reddy Garu, and his team for inviting me for today's lecture on theory of property and IPRs. As a teacher of jurisprudence, I come across various legal concepts. Therefore, my approach to the topic is from jurisprudential perspective. Jurisprudence is also a compulsory course in all law programs. Jurisprudence is a subject that deals with definitions, concepts, and theories. Definition of law, concept of law, and theories of law is the essence of the subject of jurisprudence. However, this jurisprudential study was extended to cover not only law as a legal concept, but some other fundamental legal concepts. If we take any standard work on jurisprudence, we can find analysis of certain legal concepts. What is definition, what is concept, what is theory, though we need not examine in detail. Definition has a definition, concept has some meaning, theory has some idea. What is meant by theory, what is meant by concept, what is meant by definition. Generally, definition means by using a few words and expressions, the whole phenomenon or a thing which is the subject matter of definition has to be covered. All aspects, all attributes of that particular phenomenon or the thing which has been the subject matter of definition has to be covered by using a limited number of words and expressions with an acceptable brevity. Generally, definition would be in one sentence, maybe a rule of language. Then concept. So concept is an idea expressed in words. This conceptualization is taking place out of usage, application, interpretation, etc. Where it is not possible to have a single satisfactory definition, generally we adopt a method of elucidation. That is, explaining its essentials or characteristics or attributes. There are certain terms which are conceptualized. It is a word or a set of words that express a general idea concerning the nature of something. Conceptualization is the process of organizing our perception and giving a label to it. If we use the term property, or if we use the term right, it conveys some idea. Therefore, concepts play an important role in the communication. So what does it convey? What does it mean? What are the various facets of that particular expression? We have a number of concepts, like concept of social justice, concept of natural justice, concept of distributive justice, concept of constitutionalism, so on and so forth. Here in our title itself, we have two concepts. One is That is, title means IPR. In the expression intellectual property rights, there are two legal concepts. One is property, the other one is right. What is meant by property? What is meant by right? The word intellectual, it is used with its ordinary sense, with its ordinary meaning. But these two expressions, property and right, are legal concepts. Why they are legal concepts? We go further. Similarly, a theory is an integrated body of knowledge, including definitions, assumptions, general propositions concerning the given topic, given, subject matter. It is so comprehensive. Theory includes within its fold definitions, principles, concepts. That is why it is an integrated body of knowledge, covering a given subject matter. Keeping in view the difference between definition, concept, and theory, we examine the term or the expression intellectual property rights before discussing various theories of property. There are many theories. Theories are developed over a period of time to serve different purposes at different times, either to justify the concept of private property or the protection of private property or the nature of property or origin of property or the functions of property, the social functions of property. Different theories are developed by different scholars at different times to serve different objects. Since jurisprudential study is extended to cover, after examining the nature of law, then study is extended to cover certain legal concepts. I took it from Salmond on Jurisprudence, the third part of the book dealing with legal concepts. What has been discussed by Salmond under the head legal concepts: legal rights, ownership, possession, persons, titles, liability, and proceeded further: the law of property, the law of obligations, the law of procedure. In the last three topics, the word law is added. It is law of property, law of obligations, and the law of procedure. Whereas other topics listed out here, simply legal rights, ownership, possession, persons, titles, and liability. So generally, in the subject of legal theory or jurisprudence, we deal with definitions, concepts, and theories, not the provisions of law. Legal provisions may be, invoked incidentally or contextually. It is not the study of law. It should be the study of the concept. Whether property is a concept. So if it is a concept, why the title of the chapter is the law of property? I had gone through the lesson on the law of property. There is no list of theories or any theory. Only the various forms of property, various, modes of acquisition of property, that has been the discussion. There is a reason behind it. However, some other textbook writers treated property as a concept. Therefore, definition, conceptual framework or analysis and the various theories or theories of property covered in some other works on jurisprudence. Anyway, the list is presented here to show that there is an interrelation or connection among the various expressions or the legal concepts. Why in the property, in the topic given for this lecture, intellectual property rights. What is meant by right? What are the characteristics of a right? How to determine the existence of rights? Then we have to go through the chapter or the lesson on legal rights. Then property and ownership, related concepts. They go hand in hand. They go together. There is a discussion on the relation between these two concepts. What is property? What is ownership? Are they same? Are they different? Since property is the subject matter of ownership, we have to again go through for a proper understanding of this property law, whether it is intellectual property law or other properties, we should go through the concept of ownership. Then possession. Possession being an important attribute of ownership, that is an important element of ownership. So what constitutes possession? So what is possession in fact? What is possession in law? There it needs some exposure, some study. Then persons. Even for a right, there must be a person to hold it. A right cannot exist without a person. Right can reside only on a person. Person may be a natural person or juristic person. When we speak of property rights or intellectual property rights, even person is also another important element. Then titles. Titles are the source of rights, where from the right is derived, the fact from which right is acquired, the source of right. Titles are the sources. The entire law is revolving around titles only. Who has a title? So this liability also. Liability arises in case of infringement. Whether infringement of any right or property right or intellectual property right, be it patent right or copyright or some other intellectual property right. What is meant by liability and what are the various kinds of liability? What is penal? What is remedial? Is it a crime or a civil wrong? If there is any infringement of any intellectual property right, is it a civil wrong or a crime? If it is declared as a crime that is punishable with some punishment, with any form of punishment, why it is declared as a crime? Why not it is a civil wrong? What made the state or the lawmaker to declare it as an offense punishable? How punishment is prescribed? If we go on, that is what. So all these concepts are interrelated. That is why they are arranged in a definite order for a proper understanding. To start with right, then ownership, possession, persons, titles, liability, then the law of property. It has been taken up later. Though property is the subject matter of a right, property is the subject matter of ownership or possession, we discuss it a little later. This is the order presented by SWAYAM in his Jurisprudence. Therefore, for a proper understanding of this concept of property or concept of right, etc. One should go through all these concepts. Then only a clear picture would emerge. However, an attempt is made here in this session to have a discussion on concept of property and concept of right. Salmon, in the continuation, Salmon's division of substantive civil law. Civil other than crime. Substantive other than the procedure. The law of property, the law of obligations, and the law of status. The explanation is given here under. The first, the law of property deals with proprietary rights in rem. That is why in many books we see the definition of property as proprietary right in rem, or meaning of property as proprietary right in rem. The second deals with proprietary rights in personam, like contractual obligations. Even contractual obligations have some economic significance. However, it is different from that of property. That is law of obligations. Obligations arising out of contracts. Then the third deals with the personal, that is personal rights, non-proprietary rights, whether they are rights in rem or rights in personam. When we are using this vocabulary, right in rem, right in personam, proprietary right, personal right, we get the relevant material from the topic legal rights. What is personal, what is proprietary? On what basis rights are classified into personal rights and proprietary rights? Then again, rights in rem and rights in personam. Then coming to the meaning of property, as given in Salmon's jurisprudence, different meanings given to the expression property. The meaning has been steadily expanded. 4 different meanings of the property. 4 different meanings out of usage. One meaning is all legal rights. All legal rights that a man has or an individual has, including right to life, right to liberty, everything. All legal rights are treated as assets of an individual. They are treated as property. That we have an explanation. Then proprietary rights. Not all those rights, it has been further narrowed down. In its wider sense, property includes all legal rights. But in its restricted sense, that is narrow sense, so proprietary rights, not personal rights. Personal rights are rights relating to body, rights relating to status, such as right to life, right to liberty, or right to privacy, right to health, so on and so forth. Proprietary rights, those rights which have some economic significance, pecuniary value, those rights which constitute wealth. They are called as proprietary rights. Therefore, that is the second meaning enumerated herein. Then the third meaning is further narrowed down. Not all proprietary rights, only proprietary rights in rem. They are the rights in rem means rights against all, rights against the world, because the corresponding duty is imposed on all others. That is what we call exclusive right. It is a right against all others, excluding all others. All others are under duty to respect our right. Then it is a right in rem. And it should also be proprietary in nature. Even personal rights are also, some personal rights are also rights in rem. Like right to life, right to reputation, right to privacy. They are also rights in rem. Rights against all. However, here property means those rights in rem which are proprietary in nature. Dual test is applied. It must be a proprietary right and it must also be a right in rem. So this is the third meaning. Fourth meaning is corporeal. That is very, very restricted sense. Property means only corporeal things. Corporeal property. That is to say physical objects. Those things which occupy some physical space. The corporeal properties. So property means only corporeal property, to the exclusion of incorporeal things, incorporeal properties. Later on, there is, I think, the meaning of property has been expanded, but it is also one meaning assigned by the scholars as well as jurists in their juristic thought. Even that is, there were some, I think, subscribers or theorists who supported the contention that property means only corporeal property. Extending the term property to cover incorporeal things or incorporeal properties is a metaphor. It was seen as a metaphor. However, so these four meanings of property further explained in the coming slides. All legal rights. In its widest sense, property includes all a person's legal rights of whatever description. That is what we discussed. A man's property is all that is his in law. This view Locke, the statement of John Locke in his Leviathan. So every man has a property in his own person. He speaks of man's right to preserve his property, that is, his life, liberty, and estate. This theory has a greater influence on the legal development. Though there are, I think, there is a criticism and shortcomings of the theory, but the theory has a greater impact on the legal developments. So all that is in his body is the property, without that is excluding any right. Anyway, we come to the proprietary rights. In a second and a narrower sense, property includes not all person's rights, that is not all rights of a person, but only his proprietary as opposed to his personal rights, which we discussed. In this sense, we may oppose to Locke's statement that a man has a property in his own person. Personal rights are excluded. The proprietary rights in rem. That is what the present definition or meaning of property. The term property includes not even all proprietary rights, but only those which are both proprietary and in rem. Salmon says the law of property is the law of proprietary rights in rem. If it is proprietary right in personam, it is under law of obligations. Corporeal property in the narrowest sense or use of the term, it includes nothing more than corporeal property. That is the right of ownership in a material object or that object itself. This is the theoretical controversy. Whether ownership of a material object constitutes property or the subject matter of ownership, the thing over which the ownership is exercised, is property. These are the two different concepts. Ownership is always incorporeal, because ownership denotes the relation between a person and a thing, the legal relation between a person and a thing. Relation is always incorporeal. But property can be either corporeal or incorporeal. Therefore, the material object of the proper ownership, that is the thing over which the ownership is exercised, that is property. It can be either corporeal or incorporeal. So here property is defined as material object. That is very, very restricted meaning of the term property. The meaning has been expanded steadily from time to time. So the four factors, the four reasons why this meaning of property has been expanded. One is social contract theories. Social contract theories recognize property as a natural right. in an informal contract between the people and the state, the people conferred power or surrendered power to the state in order to protect their rights, especially the right to life, right to liberty, and right to estate, right to property. To protect their life, liberty, and property, power is conferred on the state. The source of political power is will of the people. Therefore, state is under duty to protect these rights of individuals. They are labeled as natural rights: right to life, right to liberty, and right to property. Property has been given importance on par with life and liberty in many juristic writings. Then the second one, when property was declared as a natural right, that is inalienable right, which cannot be taken away by the government or the state, then what constitutes property was the issue. Then the second one, equity jurisdiction in England. You all know equity was developed by the side of common law. When remedies are not provided under common law, remedies were provided under equity jurisdiction. This equity played an important role in protecting the property and property rights. Therefore, the meaning of property was the issue in the equity jurisdiction. Different kinds of jurisdiction of equity. In this process, the meaning of property was expanded to bring within its clutches, to provide relief to the affected parties. The meaning of property has been expanded. Then the constitutional protection. In modern constitutions, there is a chapter on human rights or fundamental rights or basic rights of the people. And right to property was also guaranteed as a basic human right in some of the constitutions, including the Constitution of India. Even right to hold, acquire, and dispose of property was a fundamental freedom under Article 19(1)(f), and right to property was also guaranteed as a fundamental right under Article 31. Later on, it was moved to some other place for various reasons. When constitutional protection was given, or that is guaranteed, when right to property was guaranteed as a constitutional right or a fundamental right, what is the meaning of property? So this is another, I think, reason for, interpreting the term property and expanding its meaning. Then growth of new forms of wealth. That is the present day position. How the knowledge is a source of wealth. How this knowledge is converted into wealth. With the growth of new forms of wealth, the meaning of property is steadily expanded. Having discussed about what constitutes property, what is the meaning of property from theoretical point of view, then what is meant by right? Property and right, these are the two concepts used in this expression, intellectual property rights. Salmond enumerated the 5 essential characteristics of legal right. That is, every legal right has these 5 characteristics. The person of inherence, that is on whom or in whom the right resides, that is holder of the right, subject of the right. The person of incidence, upon whom the corresponding duty or correlative duty is imposed, duty-bound person, subject of duty. If rights and duties are correlated, then there must be a subject of right and subject of duty, duty-bound person and the person entitled to right. Then content of the right. Content of the right is the act or omission which the duty-bound person ought to do in favor of the person entitled to right. What the duty-bound person ought to do, whether it is positive or negative. If the duty-bound person is obliged by law to do something in favor of the person entitled to right, it is positive duty, act. Omission, where the duty-bound person is prohibited from doing something. Then it is a case of omission, act of commission or act of omission. Then this content of the right is that act or omission which duty-bound person ought to do in favor of the person entitled to right. Then what is the object of the right? That is subject matter of the right, in other words. What is the subject matter of the right? The thing to which this act or omission relates. This act or omission relates to what? If that act or omission relates to something, what is that something? That is the subject matter of right. If it is ownership right, like lands or buildings, buildings become the object of the right, subject matter of the right. Then the title of the right is the source of the right, the source from which right is derived. The source from which the right is derived. So these are the 5 essential characteristics of legal right in Sarment's analysis. Here comes an issue. What is that issue? Is the object of right is essential? That is the subject matter of right. What can be the subject matter of right? In relation to their objects, that is object of the right, rights are classified like this. Rights over material things. Material things means corporeal, such as movable and immovable properties, what we know. Because we need property. Without property, we cannot live. That is why, though in Indian Constitution, property is removed from the chapter of fundamental rights, is it possible to live without property? We have to see from theoretical angle, theoretical perspective. Property is so essential. That is what theories are also suggesting. Some theories, if not all. Rights over material things like lands, buildings, chattels, they are all the subject matter. Then rights in respect of one's own person. In respect of one's own person, like life, liberty, health, privacy, etc. Then the right of reputation. Reputation is the subject matter. Right in respect of domestic relations, like conjugal rights, the rights of parents over their children. So that is love and affection may be the subject matter of those rights. Right in respect of other rights. Sometimes another right may become the subject matter. Then rights over immaterial property. Immaterial means incorporeal property. That is what we are concerned. That is what we are going to discuss here in intellectual property. Rights over immaterial property. That is incorporeal property. Even incorporeal property can become the subject matter of a right. That is right over immaterial properties such as patents, copyrights, or trade secrets, or trade names, or trademarks, etc. Then right to services. This is how in Sarment's analysis, even incorporeal property can be the subject matter of right. That is the object of the right. Object means the subject matter. Then moving further. This is the classification of property. Various kinds of property are shown in a tabular form. Property is either corporeal or incorporeal. That is the major classification. All incorporeal properties are not intellectual properties. To make a distinction between these two, patents, copyrights, trademarks, they are known as intellectual property. That is incorporeal property, a form of incorporeal property. Leases, servitudes, securities, etc. They are also incorporeal property, but they are not intellectual. They do not come under intellectual property. Only for that purpose, we are looking into this table as given by Sarment in his Jurisprudence. These are the proprietary rights in re propria, that is rights over one's own property. Sarment enumerated patents, literary copyright, artistic copyright, musical and dramatic copyright, commercial goodwill, trademarks, and trade names as proprietary rights in re propria. In re propria means right over one's own property. That is incorporeal property. Next one. Proprietary rights in re aliena means these are also proprietary rights constituting some, that is having some economic significance. However, they are rights over others' property. They are incorporeal rights, that is incorporeal property. Rights are always incorporeal. Property may be either corporeal or incorporeal. So therefore, incorporeal property, but they are the proprietary rights in realia, such as leases, servitudes, and securities. There are four modes of acquisition of property: possession, because in our theories also there is a reference to possession. There is occupation theory or natural possession theory, etc. It has been observed by some that possession, prescription, agreement, and inheritance are the four different modes of acquisition of property. Then simultaneously, from this analytical, because in this analytical study, what is there in analytical approach? What is property? What is the definition of property? What are the essential elements of property? What are the kinds of property? What are the modes of acquisition of property? This is purely analytical approach without any reference to sociological and historical aspects. Why property is in the hands of a few? Why it is denied to others? Why this inequalities? Why there is no equitable distribution of assets or properties? There is no reference to it in the analytical approach. However, the sociological jurists, I think, had a bit different approach. Therefore, we are taking up Roscoe Pound's view on property. According to Roscoe Pound, a 20th century jurist, an American pioneer of sociological approach, there are four claims of individuals in their economic life. Claim to corporeal things, that is for our consumption and comforts, because we cannot live without food, without shelter, without mobile, without Wi-Fi. They are all required. Corporeal things are required. There is a claim to that is a de facto claim of every individual to corporeal things. Then claim to freedom of industry and contract. Freedom of industry here means freedom of employment, freedom of provision, freedom of contract as well, because every contract has some economic value. Then the claim to promised advantages. So claim to economically advantageous relations with others. These are the de facto claims of individuals in any society, which individuals seek to realize or to protect. Economically advantageous relations with others. That is the claim of an individual, de facto claim of an individual. How far these de facto claims are recognized by law and protected by law is subject to examination. Even if it is an invention, if it is an invention, what the inventor can do with it without public relations. Without public relations means without any trade, business, or industry, what that invention, in what way invention will help the inventor? Therefore, public play an important part, no. In the economic development, public are also the participators. They play an important role. Therefore, the claim to economically advantageous relations with others. There must be freedom of trade, freedom of occupation, freedom of profession, freedom of business, so on and so forth. These are the claims, de facto claims of individuals in their economic life aspect. Roscoe Pound considers property as an institution. What is meant by institution? It is a social institution. Social institutions are again classified into domestic institutions, political institutions, economic institutions, cultural institutions. It is an economic institution. Means it is an accepted form of procedure governing orderly relations among individuals or the groups in a society. It has a social function. That is why property is treated as an institution. It has a social function, not merely conferring the right on individual. So it needs legal recognition and protection for the economic prosperity of any society. That is what his view. Therefore, he made an observation that every individual in a civilized society must be able to take it for granted that he can appropriate for his own use what he has created by his own labor and what he has acquired under the existing economic order. That is, individuals need protection, and also the benefit should go to the society. This is what his theory of, that is sociological theory. That is, society cannot prosper at the cost of individuals. Individuals need protection. Inventor needs protection. That has to be recognized legally. At the same time, there is a social function. Property has a social function. Those who are, that is, in possession of wealth, they should do something to the society. What is that? We will further examine. Then Roscoe found further, that is, analyzed this property, stating that it includes 6 rights, 6 different rights. It is also the same has been covered in the concept of ownership also. Ownership and property, they go hand in hand. Ownership is also not a single right. It is a bundle of fragmented rights. It is a bundle of fragmented rights. Right to possession, right to enjoy, right to dispose, right to abandon. Like that, there are several rights. So, jus possedendi, that is the right of possessing. It is a right in strict sense of the term. That is right of possession. Then, if without possession, what is the use of the property? It is one aspect, one important attribute of property. The theories also subscribe the view that possession is the basis for ownership. Possession has been the foundation for generating ownership. Then jus prohibendi, that is the right of excluding others. It is also right in the strict sense. Jus disponendi, that is the right of disposition, that is the power of alienation, what we should now call as power. It is a power, because in wider sense, right includes powers, privileges, and immunities. That is what the analysis. So the first two, they are the rights in strict sense. That is the right of possession and the right of excluding others. They are the rights in the strict sense. The third one, that is the right of disposition. It is the power. It is power on the part of the owner of the property. Then jus utendi, right of using. Right of using, what we should now call liberty. It is a liberty to use or not to use the liberty. Liberty means what one may do for himself. He may use the property, may not use the property. Still, he is the owner of the property. Therefore, it is a case of liberty. That is a kind of freedom. Jus fruendi, right of enjoying the fruits and profits. That is also a case of liberty. That is also a case of liberty. That is the liberty of enjoying the fruits and profits arising out of that property. Jus abutendi, that is the right of destroying or injury if one likes. Right of destroying, abandoning. Right to leave a thing. Right to destroy, that is also liberty. If he likes. If one likes, he can also destroy the property of his own, but subject to legal restraints or limitations. These are the 6 different rights which are included in the concept of property. Property, that is what? Right of possession, right of excluding others, exclusive use, right of disposition, right of using, right of enjoying the fruits and profits, right of destroying the thing. That is our injury if one likes. In this list of 6, the last 3 are liberties. The first 2 are rights. The third one is power. First 2 are rights. Third one is power. The last 3 are liberties. This analysis shows how property is tied up with liberty. At least half of the content of right to property is liberty. Out of 6, 3 liberties, 2 rights, and 1 power. Why this liberty and property go together? Why they are given equal importance? We have seen right to life, right to property, right to liberty, and right to property. How liberty and property are connected, this is one analysis. Therefore, for further understanding, see the relation of rights, liberty, property, and law. With this background, with this jurisprudential analysis or background of this concept of property, because it is like property, ownership, possession, they are all identical, related concepts. But what can be the subject matter of property? Is it corporeal or incorporeal? What type of incorporeal properties become the subject matter of property? That is what we had a discussion. Then theories are generally outcome of some research. Theories are outcome of research. Lot of research was carried on because it is the result of juristic thinking. It is the result of juristic thinking. They did a lot of research in explaining the nature of property, the object of property, functions of property, and the protection of property. We have two different sets of theories. One set of theories explaining the origin of property, the nature of property. Another set of theories dealing with the functions of property and restraints on property, and also the justification of private property. While justifying the concept of private property, the need for restraints, the need for restrictions, or the regulation. So this is how different theories explain different aspects. Quickly we sum up these theories, then how they are relevant in understanding the nature of intellectual property rights, you can easily, understand. Natural law theory or natural rights theory, also known as occupation theory. That is natural possession. Possession was the basis. Hugo Grotius, Pfaender, Samuel Pfaender, William Blackstone, they were all the exponents of this theory. Means originally, according to Grotius, originally, all things were without owner, res nullius, ownerless things. Then who had a physical control over the ownerless things, that is possession. Physical control means possession. Those who have possession of those ownerless things was the basis for generating ownership at a later point of time. This was how the concept of property came into existence. At one point of time, it was only a group property, common holdings, joint holdings. But with the passage of time, there was disintegration of social groups. This was how the natural possession was the foundation. Natural possession, that is the de facto possession. It was the de facto possession who exercised control over a particular thing. They became the owners of those things. It is also natural rights theory. In this natural law concept or natural law theory, there is a reference to natural rights. We already referred to social contract theories. Thomas Hobbes, John Locke, Jacques Rousseau, they were the exponents of social contract theories. Natural rights concept. They are the rights acquired by birth. Everyone is getting these rights by birth. Everyone is getting a membership of this society by birth. Therefore, by birth, they acquire certain rights, including especially right to life, right to liberty, and right to property. This theory was used, in fact, natural rights theory was developed in order to put restraints on governmental power. By declaring these rights as natural rights, putting limitations on governmental powers. That the state is not justified in taking away of these rights. State is under duty to protect those rights. State is not justified in snatching away of these rights from individuals. This is what natural law theory or natural rights theory. Then metaphysical theory or personhood theory. Hegel, Immanuel Kant were the subscribers of this theory, metaphysical. Though in jurisprudence we cover natural law theory, divine theory, metaphysical theory, and all these idealistic theories in one topic, but a slight variation. The metaphysical ideas of liberty, property and liberty, the connection between property and liberty. So therefore here Hegel and Immanuel Kant, they developed theories in the light of freedom of an individual, liberty of an individual. That is, property is essential for the development of personality. That is why what we say, even to stand on this earth, a square foot of property is required. How is it possible to live without property? How is it possible to have livelihood without property? How is it possible to have comforts or, I think, consumable goods without property? That is why personhood theory or the metaphysical theory, no meaning to liberty without property. Property is essential for the development of personality. This is how the theory has been developed. The approach was metaphysical. The approach was metaphysical. Now we are in scientific era. The thinking, in human thinking also there is a change. That is why it has been commented by one scholar that like change in fashions, there like changes in fashion, sleeveless, short sleeves, full sleeves, 3/4 sleeves, like that. Here also there is a change in juristic thinking or human thinking. There are different styles. There are different approaches. So at one point of time, that is, every branch of learning was labeled as philosophy. Philosophy of music, natural philosophy, philosophy of law. This was how the word philosophy was used. Every branch of learning was styled as philosophy. Then, over a period of time, those philosophies became histories, history of law, like that. Then philosophies and histories had become sciences. Now it is science of law, political science, science of sports. This is how the word science is very much in use. Why we say metaphysical? The approach was metaphysical at that point of time. Then historical theory or evolutionary theory. What it is, that is, the private property is or it has slow and steady growth. That is, from natural possession to juristic possession, from juristic possession to ownership. With the passage of time, individual became the unit of the society. Individual is the unit. Therefore, the recognition, legal recognition of individual ownership. Individual ownership. Though at one point of time the property was held by a group, even family was the unit of the society during ancient times. But today individual is the unit. Therefore, the recognition of individual ownership. Individual is the holder of the property. So this is how historical theory or evolutionary theory described or I think narrated the concept of private property, how it came into existence. Then positive theory and labor theory. Maybe in some, because vocabulary, these are different writers who use different expressions. Positive theory. What is this positive theory or labor theory? As we discussed already, everyone's expectation is that, the legal expectation is that he can use for his own benefit anything that has been acquired by his own labor. by his own effort, either by physical labor or by some intellectual labor. What has been created, what has been invented, what has been acquired by his own effort under the existing economic order, he should have the control of it. He should have the title over it. This is how the labor theory or positive theory has been evolved. Then psychological theory. This theory subscribes the view that it is the acquisitive instinct of man. Man is neither, I think, that is selfish by nature, undoubtedly. Not altruistic all the time. Maybe altruistic at some times. Since he is selfish, he is greedy, he wants to acquire wealth. This acquisitive instinct of man is the cause of the existence of property. That is the acquisition instinct, that is psychological. That is the motivating factor. Why there is authorship of a book? Why there is creation of some property? Why there is some invention or so, something like that? There should be some motivating factor behind it. It is that is acquisitive instinct of man that is the cause for the existence of property. That is what known as psychological theory. Then the sociological theory, though Roscoe Pound's contribution we discussed earlier in brief, Duguay, a French scholar belonging to sociological school of jurisprudence, was of the view that property is not a right. Property is a social function. Property is not a right. Even Kelsen too rejected the concept of rights. Even Lundstedt, a Scandinavian jurist, held the view that law does not confer any right on individual. Duty is the essence. Duty is the essence of law. Duty-oriented approach. What is the duty here? Those who are in possession of wealth, that is property, they have some social responsibility. Therefore, property has a social function. That is the welfare of the public welfare or social welfare, or for the well-being of the society, or for the economic prosperity of the society. That is why there is a doctrine that rights must not be abused. Those who are in, if at all, those who are in possession of certain rights, it is a social duty implicit in every right that rights should not be abused. Because when there is a right, there is scope for its abuse. If it is power, that is, if it is power, the more scope for its abuse. Therefore, the social duty is implicit in it, that this right must be exercised, that is, without causing any harm to others. Therefore, it is in this balancing process, protection of individual's right, his invention or his creation or his acquisition. On the other hand, the welfare of the public, as we discussed earlier, without public, what this right can, I think, what a person can do with a right. A right has an economic value or significance only with the presence of the public and others. There is a sole individual, even if he has a large, that is, number of rights, what is the use of those rights without the participation of others? So this is how the connection between individual and the society has been examined in these theories. Therefore, this sociological theory is justifying some restraints or restrictions or limitations on the exercise of these rights, so as to protect the social interest, so as to protect the members of the society. This is the balancing process. That is what sociological jurists advocate in general. Then utilitarian theory. In fact, Bentham was the founder of this sociological approach in his utilitarian theory. What is this utilitarian theory? Bentham's view, the principle of utility. Maximum happiness or maximum number, the greatest good of greatest number. He was an individualist. Bentham was an individualist, individualistic philosophy. That is why he represented that laissez-faire era, non-intervention of government, maximum liberty to individuals, minimum interference of government. There is only justification to interfere in the individual activity is to prevent harm to others. So long as individual conduct is not harmful to others, state need not interfere. This is what his approach. However, in this maximum greatest good of greatest number or the maximum happiness of maximum number, the welfare of the society should also be an important aspect. Therefore, utilitarian theory is the one which laid the foundation for the present-day sociological approach. So this is how we have different theories conveying different ideas in relation to the nature of property, origin of property, functions of property. There is several issues are there which are being addressed in course of time with the help of these theories. One is expanding the meaning of property. The second one, protection to property rights. The third one, the concept of private property. Then the fourth one, the functions of property, social functions of property. Because right cannot exist without duty. Duty is also implicit in every right. Even you see international charters on human rights also, now they are human rights and duties. Duties always imply rights not to be abused. So this is how various theories have been developed, explaining the nature of property. So in jurisprudence, in the subject of jurisprudence, we cannot find, in fact, any special reference to theories or protection of intellectual property rights. Probably these theories may hold good even to cover this incorporeal property and also intellectual property rights. So this is what my understanding of this subject.
Thank you, sir, for the lucid presentation of a relationship between the theory of property and intellectual property rights. Now I request our IPR-Chair professor at DPIIT IPR-Chair Osmania University, Professor G.B. Reddy, sir, to please proceed with the session.
Thank you so much, sir. Thank you, Dr. Irfan. Sir has clarified so many things. In fact, nobody really thought about the jurists or the modern lawgivers like Solomon talking on copyright. And it is a revelation to all of us. Like, because, in our quest to learn something, we confine ourselves mostly to the intellectual property books, sir. Whether it is Cornish or, Bainbridge or Narayanan or someone else. But the jurisprudential aspects, I think they need to be understood much better, and they can be understood much better only if we are exposed to the scholarly expositions like the one made by Professor Y. Pratap Reddy, sir. Really, it has been a feast to hear or listen to your lecture, sir. And we are really very happy. I am very sure that the remaining participants also must have really cherished as well as relished whatever they have learned from the jurisprudential perspective of the property and theories of property. And we wish to have many more, such presentations from you, sir. The core issues, unless we understand them, it will be very difficult to advance the intellectual property rights jurisprudence. Thank you so much, sir. I thank our team from Osmania University, IPR-Chair, Dr. Irfan Abbas, Mr. Nagaraju, Mr. Srinivas Rao, Miss Vaishnavi, and others for making this evening a wonderful one and a fruitful one. Now it's over to Mr. Srinivas Rao to propose formal vote of thanks. Thank you.
Very good evening, sir. Very good evening, IPR-Chair, Professor Dr. G.B. Reddy, sir, the organizing team, and all the participants. I would like to take this privilege to host a vote of thanks on behalf of DPIIT IPR-Chair OU. First of all, I would like to thank you for accepting our invitation, sir, and helping our viewers and participants in aligning their theories and concepts. We have often seen the basics are misplaced. Therefore, today's lecture plays a vital role in enhancing and refreshing the knowledge of the participants and the viewers. Sir, you made this lecture very lively and virtually interactive by your examples and interrelating the IPR concepts and IPR jurisprudence concepts. With your lecture, sir, we have completed our 10th episode of our weekly lecture series, Know Your IP, which is one of the DPIIT IPR-Chair's OU IPR properties. And I must acknowledge that it would not be possible to take up such a challenge without the help of resource persons like you, the interactive participants, our online viewers on YouTube, and most importantly, supporters who are the part of this organizing team like Dr. Irfan, Mr. Nagaraju, Ms. Vaishnavi, Mr. Suresh, and the others, which is led by Dr. G.B. Reddy sir himself. And this is the first of its kind that we are organizing and executing it effectively. And with the help of supporters and our participants, we are sure to take this to a new height again. Having said that, I would like to thank our viewers and participants, and also would like to request them to please circulate the lecture series registration links in your circles and WhatsApp groups, as we believe that this knowledge and awareness should be propagated to more masses, and we shall succeed in our agenda if a common person would easily relate his IP rights and would tell us and give a lecture on IP jurisprudence in his own words. By these series of lectures, sir, that we are organizing, we as you, we the organizers, and the viewers have become an exclusive institution for disseminating the knowledge and creating awareness. This cannot be moved forward if you don't pass on that registration link of the lectures to others. So I would request you to please pass on the registration link and share on your YouTube link with the interested members. With that note, I once again thank everyone, especially Dr. Pratap Reddy sir, for taking out your precious time and sharing your knowledge with us. We will meet again with yet another interesting topic. Until next episode, on behalf of DPIIT IPR-Chair OU, thank you. See you again. Thank you, sir.
Thank you.
Thank you, everyone.
Thank you, sir. Thank you so much, sir.